I joined there also in the YouTube also.
Achha. So how many are there right now?
There also in the YouTube also. As of now, I think there is
19.
Okay.
19.
So how many are there right now?
Just 1 second. Now it is already streamed. Can somebody stop that now? Pranay? 19. We already streamed, Pranay.
Yeah.
When we start, we'll because others are now listening what we are talking here.
No, it is 30 now.
So I would.
Pranay, are you there? Professor Rajiv, already streaming started. Professor Rajiv, am I audible?
Yes, sir.
This, YouTube streaming.
We will control. We will control. Good morning to all of you, and welcome to this workshop. I think Dr. Sabath, you can.
Yes.
Yes, we can start now.
Good morning, everybody. Myself is Dr. Samrat Sabath, professor at University of Hyderabad and member coordinator for IPR activities at UoH Institutional Innovation Council. Respected Professor Agrawal, Pro Vice Chancellor and President of UoH-IIC, dear Professor G.S. Prasad, Vice President, UoH-IIC, my dear Professor Rajiv Wankar, my dear friend, right, who is the coordinator for this workshop, Professor Salman, who is the convener of the UoH-IIC, and distinguished speaker of the day and distinguished participants, ladies and gentlemen. It gives me a great pleasure to welcome all of you to this virtual platform where we are holding in one-day workshop on intellectual property rights jointly conducted by UoH-IIC and the Technology Enable Center, University of Hyderabad. Today we are gathering around 700 participants in this platform throughout the country. I would like to welcome all of you to this workshop. We live in a constantly changing environment. We can see this as an example from offline to online. We are now in this virtual platform organizing this workshop. But apart from that, the focus is also changing from a different perspective. Earlier, we were all talking about the tangible assets, but now we are talking about the intangible assets. And the country or the people who has a lot of innovative skills, he is the leader, or the country who has a lot of innovation, he will lead the future. It is already set, it's already decided, already known. So we have to safeguard these intangible assets. IPR takes care of that. So the intellectual property right takes care of how to safeguard the intangible assets of your innovations, right? So we decided that, or we thought that it's the right platform, the right time to make the academia aware of this IPR activities. And with this objective in mind, we started giving this workshop. My friend Professor Rajiv will tell more about this workshop, but I welcome all of you to this platform, and I hope all of you will enjoy this one-day workshop, and you will know many things about the IPR activities, IPR from the distinguished speakers. With this, I once again welcome all of you to this platform. Now I thank you all, and I would like to invite Professor G.S. Prasad, Vice President UoH-IIC, to speak about IPR activities at UoH. Mr. Prasad.
So good morning, all of you. Welcome you to this one-day workshop on IPR. We are thankful to the President of the IIC, Professor Arun Agarwal, for coordinating this activity with active support from Professor Salman and Rajiv. Rajiv, I think it is heartening to note that I think about 700 people have registered for this workshop. Let us see how many of them will be actually joining. So I just wanted to share you what are the activities we are doing as a small IPR cell, what we have in the University of Hyderabad. See, as a university, we publish about 900 to 1,000 publications every year. See, almost half of them come from science and engineering schools. That means about 500 publications come from these science schools. And as a university, so far we have published close to 15,000 publications with almost around 2 lakh citations. So now compare this with the number of patents we have in the last, since inception. So as a university, we have filed about 75 to 80 patents. These are at various stages. Some of them are granted, some of them are filed. This includes 4 US patents that were granted to the university. So now for the last couple of years, we are emphasizing and requesting the faculty and students to take advantage and file the patents. See, when you file a patent, there are dual advantages. See, you get the advantages of the patent. Later on, you can also go for publications. So the trend is slowly changing. As of now, what we do in the university is, when somebody comes to us for filing a patent, we request them to go for a patentability search report. That means it gives you an indication whether a given invention is worth filing a patent or not. Why we do that? Because unless you do that, once you file the patent, at a later stage you come to know that it is not worth filing the patent. You are losing the effort and money also. So once they complete that, the university steps in and supports the filing the patent costs, etc. And we have also established a small Innovation Facilitation Center supported by NRDC, that is National Innovation and National Research and Development Corporation. And they are also helping in the patent report search. We are also coordinating with the TIFAC to open their small center here in the university. During the last 2 years, we have organized 3 workshops. Some of them are in collaboration with the Indian Patent Office. So with this few words, I request the chairman of the IIC, Professor Arun Agarwal, to formally welcome the participants. Thank you.
Yeah, thank you, Dr. Prasad. On behalf of the university, I welcome our esteemed expert speakers, distinguished guests, members of our University Institution Innovation Council, faculty, students, and dear participants from Pan India. Our distinguished expert speakers for the workshop are Dr. Venkata Reddy, Donti Reddy. Ji, I welcome you. Dr. Venkat Reddy is advocate and IPR attorney with RVR Associates, Hyderabad, India. Our second expert speaker is an entrepreneur, Dr. Nandita Sethi, founder and managing director of Entrepreneur Zone. I welcome Nandita. She's also a very close friend of ours. And I would also like to mention Dr. Arati Tyagi. She is an associate professor at Pendaganti Law School, where she is teaching, in Faculty of Law, and she also teaches IPR in that. I wish to welcome all 3 of you, and for kindly accepting our invitation at a very short notice. I also have understood that there are over 700 participants have registered for today's workshop all across the country, as was mentioned by in the opening remarks by Dr. Samrat Sabat, which I think shows the growing interest in this area of IPR. I would like to give a little background. That Ministry of Education, the Government of India has established MOE innovation cell called MIC to systematically foster the culture of innovation amongst all higher secondary education institutions. The primary mandate of MIC is to encourage, inspire, and nurture young students by supporting them to work with new ideas while they are in formative years. MIC has envisaged creation of Institutions Innovation Council across selected higher educational institutions. University of Hyderabad's IIC was established for this purpose, which is to foster innovation ecosystem in the campus. Over last several years, we have made several attempts, like to encourage this culture is to participate in the Atal ranking of institutions on innovation and achievements, which will benchmark us how well we are doing as compared to other institutions across the country. We are also nominating some of our faculty members for innovation ambassadors training, which will be soon conducted by the Ministry of Education Innovation Cell. We also have planned an innovation club for our students to think and tinker with their ideas. And we also have been encouraging our students to participate in Smart India Hackathon, which is a national event since 2017. And we the university is also in process of creating a pre-incubation facility for successful teams who win some accolade at SIH. We have conducted innovation and startup orientation programs on National Innovation and Startup Policy 2009. And also we, as part of the National Education Policy, we have also had an orientation session on innovation and entrepreneurship. We do like to celebrate the Innovation Day, which is conducted all across the country. And recently, on 20th May, we had an interaction session with a successful startup founder, which was very inspiring, and a lot of participants had enjoyed the journey, which was taken by one of the founders. And we had invited Dr. Venu Kondakaya to explain his journey from how he started his idea, conceiving the idea, and then seeing how a company could be started. And then we also do participate in National Innovation Contest, which was held in 2020. This is a joint contest which is conducted by MIC and AICTE. And now today's workshop on IPR is indeed another very important activity in the changing times. And this workshop is being organized with the aim to create awareness of critical aspects of IPR. I would like to leave the matter in the hands of our distinguished speakers, and I wish the workshop all the best. I would now like to request Dr. Rajiv Ankar to conduct the proceedings, and by giving brief introduction about the IPR workshop, and then we can invite our experts to give their lectures on this important theme. Dr. Rajiv Ankar.
Thank you, Professor Agrawal, and good morning to all of you, and welcome to the one-day online workshop on intellectual property rights. To begin with, let me thank you all for showing such an unprecedented response to our call for this workshop. Intellectual property rights are the rights given to the person or the creation of their minds. They usually give the creator an executive right over the use of their creation for a certain period of time. Realizing the subject's importance, the University of Hyderabad started the one-year postgraduate diploma program in cyber law and intellectual property right in the distance education mode 22 years back. The PG diploma program has equal emphasis on cyber law and intellectual property right. The PG diploma is the first program in the country with unique blend and one among the most popular courses run in the distance mode from our city center, popularly known as Golden Threshold, which is a heritage building, house of Bharat Kokila Srimati Dr. Sarojini Naidu. There are many types of intellectual property, and most well-known types are copyrights, patents, trademarks, and trade secrets. The primary purpose of intellectual property law is to encourage the creation of a wide variety of intellectual goods. To achieve this, the Indian and international laws give people and businesses property rights to information and intellectual goals they create, usually for a limited period of time. It is stunning to know that 9 new billionaires have emerged in the past year from the pharmaceutical companies after the current pandemic. Stephen Bancel, a citizen of France and CEO of Moderna, tops the list, earning USD 4.3 billion in past 5 months alone. These billionaires have made their future mostly through the property rights and patents for inoculations. The workshop at Institutional Innovative Council at University of Hyderabad on IPR is organized with the aim to make the participants aware of some critical aspect of IPR, how to make huge influence through IPR in everyone's life, and the participants would be ready to play a major role in the IPR world. In today's workshop, several important topics will be covered. Few of them to name are introduction to fundamental aspects of IPR, introduction to patent regime in India and abroad, and registration aspects. Some of the critical studies and judgments and general information on IPR cases. To disseminate knowledge on copyrights and their related rights and registration aspects. Introducing the trademarks and registration aspects. Introduction to design, geographical indication, international law of patents, trademarks, and industrial design and Indian regulations. The eminent speakers for the workshops are invited who will try to cover all the facets of IPR in a day-long workshop. There could be some overlap in the topic of discussions, which is unavoidable. The speakers of the workshops are a practicing IPR attorney, an entrepreneur, and a senior faculty of law teaching IPR. Professor Agrawal has already introduced to you about all the speakers. There are certain other things which I'd like to tell from the point of view of the organization committee of this workshop, because they have decided to take the attendance after each session, and the participation certificates will be given to those who attend the complete workshop. We will be putting the Google link form in the chat box in the YouTube at the end of each session. And one more thing, since we are all working from home because of the lockdown, so some disturbance from the outside is inevitable. We apologize you in advance. Now, may I take this opportunity to introduce to you the speaker of the today's workshop. And the first speaker is Dr. Venkat Reddy. He is an IPR attorney, advocate, managing partner, MS RBR Associates. Dr. Reddy did his MA, LLM, PG Diploma in HRD, PG Diploma in ADR, PG Diploma in Cyber Law and IPR from University of Hyderabad, a proud alumnus. Then he did his PhD in law. His areas of specialization includes intellectual property right matters, constitutional matters, mines-related matter. He is the founder of MS RBR Associates law firm with the strength of more than 15 advocates, branch offices at Chennai, associate office at Delhi. There are several achievements in his bag. He is a vice president of International Association for the Protection of Intellectual Property. He is a life member of the Federation of Andhra Pradesh Chambers of Commerce and Industry. He is a life member of National Institute of HRD, a life member of High Court of AP, Telangana Bar Association. He is a president of ALERT, which is Acumen Legal Education Research and Training, an NGO. He is a member of International Trademark Association. He is a guest faculty at University of Hyderabad who teaches the IPR students. Also a guest faculty at Osmania University Law College. He is a professor at Nalsar University of Law, Bangalore, PG College of Law, Osmania University. He has been invited as a speaker at Global Intellectual Property Convention. He is a speaker at World Intellectual Property Forum, also at Bhavan College, Vishwabharati Institute, and the list is very long. He has completed his PhD in trademark subject from Osmania University. There is one more feather in his cap. He served as a full-time term with Indian Air Force before starting his career into IPR. So let us welcome Dr. Venkat Reddy for his talk. Welcome, sir.
Thank you, sir. Thank you. Thank you, Professor Vankarjar, and thank you, Dr. Samrat Sambat Saab, Sri G.S. Prasad ji, and Professor Arun Agarwal Saab for inviting me to this event. And I'm really excited because I am the student of this institution, and I get an opportunity to speak before the audience. I am told that there are around 700 viewers, and it's a great privilege for me to be the part of this great workshop. And thank you so much, sir. And this is a very right subject. It is being chosen now, as Professor Raju Vankar sir has rightly told. Many of the pharmaceutical industries heads have become the billionaires in the last 1 year. Now it's a reason only just because of intellectual property rights, and also there is a heavy demand for giving the compulsory licensing of the manufacturing of Covaxin and Covishield. And this is really the subject because which is to be discussed at length, and whether to be the compulsory licensing to be given, and what is the role of the government, and what are the modalities to be worked out. It is a very debatable subject, and rightly said by Professor Raju Vankar Saab, there could be the overlapping of the subject, and I'm quite privileged because I'm the first speaker, so I get an opportunity to speak whatever I want it, and the next speakers have to take a lot of precautions on this. And definitely I'll try to not to get into their subject, because I am just giving the broad view and just broad view of the subject, intellectual property rights and the importance. And without wasting my time, my loss, I just like to get into the slides where I can start my presentation. Is a slide.
So please take your time. You can first put your slides and then we can start.
Yes. Is it available on the screen, sir?
Yes, now it's available, sir.
Right, great.
Yeah, you can start.
Now, ladies and gentlemen, once again, good morning to everyone. And it's a good response of the viewers, because it is the COVID has taught many things to us. And one of the most important thing is sitting at your home. You can see many things, and you can gain a lot of knowledge. And also because this is what exactly is happening in every domain of the work. People are working from the home, and we have reduced the environmental pollution. We have reduced the traffic congestion. And we are getting, by sitting at one place, especially as a council, I can say that, because as the senior councils, we are sitting at the house, we are attending the several courts at one stroke. And it has really tremendous, because every negative thing has got the positiveness. That's how we are learning many things from the COVID. Now, this is why I say this is the most important and subject, because today, the most of the people are, very eager to earn many things like real estate and movable and immovable things. But the intellectual property rights is one such thing, because this is just creation of the brain. You invent something and you get a royalty by sitting at your house. And you will be shocked to know that today in the world domain, the most successful and richest persons in the world are the persons who create something. And one of the live example I want to give it today, because as Professor Raju Wankar has already told that the pharmaceutical industries who are inventing the drug like Moderna, Covaxin, Covishield, all these people are richest persons in the world today. Likewise, when you think of in the copyright domain, the richest person is the J.K. Rowling, who is the author of the Harry Potter. You'll be shocked to know that her income is, as I am told, because I read it somewhere, because it is her per annum 2,700 crore rupees per annum, and in terms of royalty. The royalty she gets from the book she has written and the audio and video films which has come into the market. And so because after attending this session, the persons, you need not to work hard, you can work smartly. And today, these are the domains, these are the days where the people can be smart workers rather than the hard workers. And a person who is hard worker and a smart worker, he will be the most successful person in the world today. And if you recollect, because in the past, there were the people who are richest in the world are the countries which have got the enough and abundant source of oil resources. And things have changed now. The richest persons in the world are today the knowledge workers rather than the oil workers. And if you take the example of, the Microsoft Bill Gates and I already told about J.K. Rowling, the author of the Harry Potter, and Jeff Bezos of the Amazon, and these people are the richest persons in the world. And if you look into the brand image today, the Apple brand, if you want to purchase the brand of Apple, APPLE, not the company, and it is costing $100 billion only to the brand name if you want to purchase. So likewise, because something you create by brain, when you put it in the right path, and all of you are famously aware of this, all those things like today, the famous brands like Sony, Coca-Cola, Swiggy, Zomato, and Indian brands like Tata, etc. And see, the benefit of this is because once you create something of intellectual property rights, maybe it's a trademarks, patents, copyrights, or geographical indication, or trade secret, and it has to be properly registered, and you need to have a protection. And that is the whole purpose today we are discussing about the basic view of how to protect your intellectual property rights when somebody violates your rights, and how to go for the registration of it, what are the precautions to be taken. I'm sure my next speakers will be covering that subject in detail about the registration aspect and all, but in a nutshell, I will be covering the slides about this particular issue. And why this importance, why intellectual property rights are so important today. And if you look into that, because the whole domain, whole world today is running behind the intellectual property rights. The rights which today all of you are aware. And today I have read in the newspaper, there is one person by name Anandaya in the Andhra Pradesh state. We have started giving the medicines from the herbal, it's like a herbal medicine Ayurveda concept. And it was so successful, and people started earlier 1,000 to 2,000, and yesterday there was a gathering of 10,000 people in front of his house. And if the police was not able to control the crowd. And the question arises, it is a traditional knowledge, I can put it in precisely, but it has shown the wonderful results. But the problem is there is no statutory permissions to the persons to use such medicines. And in view of that, the police have taken a control of this person, and Ayush is looking into whether the permission to be granted to proceed with this medicine or not. So these are and I'll discuss elaborately about the traditional knowledge of India and how we great in our traditional knowledge, but how we are not able to put it in a proper way to go for the registration. As rightly said by Albert Einstein, if you know something and if you are not able to explain about it, you know nothing. And in India especially, there is a lot of inventions, a lot of traditional knowledge, and but we don't know how to documentation. That's the biggest problem, and the government is slowly stepping up in that aspect. And accordingly, one of the two examples I want to emphasize at this place is the patent granted to turmeric and neem. At right time, the Indian government has intervened in this, and the European Patent Office has revoked the patent given to the neem, and as well as USPTO has revoked the patent given to the turmeric. So that's how we are very poor in documentation. So it's rightly said by Albert Einstein, we may be knowing many things, but we don't know how to document and we don't know how to explain it. So importance of IPR is very relevant, because these kind of seminars and workshops give the knowledge and the awareness in the intellectual property rights is very essential to protect and create the intellectual property rights. And next comes, once you know about the intellectual property rights and you know the importance of the brand names, or you know the importance of the inventions, then the approach for the getting the registration of the intellectual property rights and the right way to proceed with and to understand about the subject and the procedure involved in the registration is also very important, that need to be taken care of. And your journey doesn't stop there, because once your brand is registered or once your invention is registered as a patent, and the question comes, violator starts. Violation of those intellectual property rights by the infringers will start in the market. And you should know also how to protect your intellectual property rights by approaching to the court of law or by various other methods, how to stop it, because invention is very difficult and copying is very easy. And imagine today, everybody, because the people who are suffering, they say that, why can't Indian government give this manufacturing of this product to several other companies? And this is the general point of view, the people think on this, but from the government point of view and the statutory limitations everybody has got, because a companies invest hundreds of crores and billions of dollars to get something being invented. It's not that is overnight the Covaxin and Covishield are being invented. Speaking from the point of the company's view, because every invention which is being, because invested heavy amount of the money doesn't end up in the proper results. Many investments, every investment cannot result in the successful invention. So thus the company invests a lot of amount on this, but definitely there should be a balancing attitude to be taken by the government, so that the person who has invented something, he has to be compensated, if not exorbitantly, at least to the extent what investment is being done, and there should be the marginal profits to be given to the inventors. Otherwise, nobody will go for the invention and there cannot be no R&D, and nobody will dare to do all these things once the government takes over the companies who have invented something. So there should be a balancing approach from the government as well as the investors to proceed with this topic. Anyhow, there are the decision makers who will look into this aspect. Now, coming to the point, what is this intellectual property rights? We all know about real estate property, movable and immovable properties. And people invest on the lot of amount on this really realistic properties. But if you look into the statutory issue, because none of the acts defines what is property. But basic ingredients of the property are three. One is the possession, enjoyment, and transferability. Now, anything that can be owned is called as a property, but that particular property should have three important criteria. One is the possession, enjoyment, and transferability. Possession is one, by virtue of its purchase, you get into the possession of the property, you are the owner of the property. And enjoyment is that you get the revenues, because you invest something on the real estate property today. After 10 years, the rates of that property will go up and you will be able to enjoy the revenues generated out of it. And third is the most important, transferability. When you don't want this property, either you should be able to sell it out or you should be able to lease it out. Now the question arises whether this intellectual property right, what we are thinking today, have got all these characteristics. If you say yes, it is, because the patents can be sold, the trademarks, brands can be sold out. So this is the possession we get by virtue of your invention. We create something. It may be a small idea, but once you put the idea into realistic things and it becomes a reality, then it may be a trademark, it may be a copyright, it may be a patent. We'll discuss in the subsequent slides. And when you own it, you should be able to enjoy the property once you go for the registration of it. And when you don't want it, it can be sold out. Like any other realistic property, you sell it out by way of, it is maybe assignment, or maybe by way of licensing or franchisee, we call it many things. So these are the things when you are able to transferability of the intellectual property is carried out. Now there are basically two kinds of property, just getting into the subject. One is the corporeal property, which we call, that's not a subject matter today. And one is the movable property. All of you know what is movable property, which is also called as a tangible property. And next one is the immovable property, which is attached to the earth. That is maybe a building, maybe any construction, that is called as the immovable property. Now, the subject of intellectual property today we'll be discussing is the incorporeal property. That is what we call as intangible property. When I say intangible property, you can't touch it and feel it, but you can sense it. That is one of the criteria for intellectual property right. Now, the intellectual property rights are also called as a conventional property, and knowing the importance of this, even in the world, it is decided as 26th April of every year is declared as a World IP Day. And many of the people may say that they have got a wonderful idea, whether that idea can be intellectual property right. No, ideas cannot be intellectual properties unless this idea is converted into some sort of realistic thing. Maybe probably your idea reduced into writing in terms of a book, or your idea converted into some sort of brand creation, or your idea converted into some sort of invention where the product is being created, that in the terms of the patent it is called, then that can only be the intellectual property. Mere ideas cannot be intellectual property rights. Now, what is the concept of this intellectual property rights? Now, when you look into the international conventions, now thinking that all the audience, most of the audience are laymen, women who are not having the knowledge about the legal background, and just to put it in a nutshell and in clarity, probably many of you are not aware of the GATT, that is General Agreement on Tariffs and Trade. India is one of the signatory for this international, one of the convention, happened in 1947 and 1948. Now, one of the best example I want to quote you, because at least the people of the generation of at least 30 years back, I think most of the present generation may or may not be knowing about the Bajaj Chetak scooter, but the 30 years back when somebody wants to purchase the Bajaj Chetak, it was so crazy. People have to wait for a booking of the vehicle for almost 2 to 3 years. And if you want a particular color, it could be more than that time. And somebody is lucky enough, somebody is in United States of America whose uncle or somebody is staying there, if you are able to get that investment in terms of dollars, maybe 6 months or 1 year waiting period is reduced. Now, because internationally the world countries have the GATT convention by virtue of the signatory India, and this whole liberalization of the economy has happened. The credit goes to our former Prime Minister, great personality, P.V. Narasimha Rao. And today, is that the situation? No. Many people, the persons who are manufacturing the motorbikes or the vehicles, cars, and the banks come to your house, they knock the door and say, you gentlemen, take this vehicle or take that vehicle. We pay to that vehicle. You need not to worry. Monthly, you can pay the installments. And that is the craze today, because we have got the option of selection. Earlier, you never had an option, because if you want to get particular vehicle, you have to wait in a queue. So that is the beauty of the international conventions, because see, the purpose of international convention is to bring the uniformity of the laws all through the world. And interestingly, this GATT is being transformed into WTO, that is in 1995 in terms of the TRIPS agreement. And there are several conventions have happened in the world so far. And in a nutshell, some of the conventions I mentioned about like Bern Convention, Paris Convention, Locarno Agreement, Rome Convention, Washington Convention, Geneva Convention, NICE Agreement, Patent Cooperation Treaty, etc. I'm not going in detail to bore you on this subject now, but at least I want to tell that in every convention, some aspect of the intellectual properties are discussed, and all the countries who are signatory to the TRIPS agreement are in binding, and all the parties who are parties to that particular conventions are obligated to put their convention, the decisions into the local laws. And the intellectual property rights is the global subject. Now, any of the real estate property, if you have got a litigation, you have to fight in the particular domain. But today, if any litigation of the Coca-Cola is there, Coca-Cola is in all through the world in every country. If the particular litigation happens with regard to the brand name Coca-Cola in particular country, that has to be governed by one of the laws, local laws, because international conventions are not binding in nature. They are only directive. Those conventions to be put it into the local laws, what we, greatly called as municipal laws, and municipal laws are more powerful than the international conventions. And coming to the further narrow point of that is, under the municipal laws, there are three sources of law. One is customs, laws made by the parliament, that what you call as the acts. And next is the judicial precedents, laws made by the courts. And out of this, all three, you will be shocked and surprised to know that custom is the most powerful source of the law. Because, for example, I will quote one example where the Child Marriage Abolition Act is there. But if you go to some parts of the world, especially in Rajasthan and all, still the child marriages are happening. And it is very difficult to control it because that is a customs which is in practice for the times immemorial. So that is the most powerful law. So likewise, these international conventions which are put into the local laws we'll be covering in the next slides, which are covering the intellectual property rights, we'll be discussing on that. Now, these customs and laws can be locally given the liberalization to some extent. For example, if you invent something in the software code today, computer code, what you call it, if you want to go to the registration of the software code or software language into intellectual property rights, in India, it can be a copyrightable. But if you take the same aspect of the invention to the United States of America, it is a patentable. So these kind of some sort of liberty is given to as per the customs, local traditions, and the government requirements. See, it can be modified. And another aspect is that in the copyright, life of the copyright in India is 60 years, whereas if you take it to the US, it is 70 years. So there are some of the issues which are liberalized. And for example, if you look into the convention, Berne Convention, where it is discussed about the protection of literary and artistic works with regard to copyright, where in the Paris Convention, protection of industrial property and industrial designs were discussed. And result of this is that the specific acts are being governed in the respective countries. Now, when you go to the Rome Convention, it is the protection of the performers and producers of phonograms and broadcasting organizations. And again, it is related to the Copyright Act. And Locarno Agreement is the international classification of the industrial designs. There is a classification of the designs under which class you go for the registration. And internationally, it is discussed to bring the uniformity all through the world. And like Washington Convention on integrated circuits, which related to the software, and Geneva Convention, it was discussed about the protection of new plant varieties. And a separate act is being constituted in India on this subject. And NICE Agreement is the one which discusses about which gives the details about the international classification of the goods and services in trademarks and service marks. Under the trademark, if you want to make an application in the particular class, the NICE Agreement decides which particular class of the goods, and you can go for the registration of it. And Patent Cooperation Treaty is a filing of international patent application in several countries, and which gives the privilege to file an application in other countries once you file an application under PCT. So these are the various sources of international conventions from which the intellectual property rights subject has come up. And these conventions, guidelines are being put into the local laws, and we'll be discussing what are the local laws in India which governs about each of the intellectual property rights. Now, first of all, then question comes why we should go for the registration of the IPR. The intellectual property rights, first and foremost important, as rightly told by the Professor Raju Wankarji, and in the last 1 year, many of the pharmaceutical industries owners have become the billionaires. One is the monetary benefit. Of course, everyone knows because we are all working for the money at the end of the day. And most important is the monetary benefit. How you get the monetary benefit is once you register your intellectual property rights. If anybody wants to use that particular intellectual property rights and they cannot use it without your express permission and consent. And if someone wants to use that intellectual property rights, they have to pay the royalty in terms of whatever the understanding entered between the parties. And next is, if somebody do not want to continue the registration and ownership over the particular intellectual property rights, normally when you're in the real estate properties, when you have got a real estate house, you let it out and you lease it out and you get the rents over that property. Accordingly, here you can do the assignment and license of IPR subject matter. Assignment is complete relinquishment of the rights over the intellectual property rights when you sell it away to some other person. And if you want to keep the ownership with you and you want to get the royalty on that particular invention of intellectual property rights, then it can be licensed to other persons for a particular period of time or restricting to particular area of operation. Then, what is that sue for infringement? But the question arises, somebody is encroaching into your property, not normally called in legal domain. Here in the intellectual property rights, it is called as infringement. Somebody is violating your rights. For example, somebody is copying your brand name. Maybe with similar name or with a deceptively similar or phonetically similar name, or if somebody is copying your invention and they're manufacturing and selling in the market, then remedy available to you to go to the court in the civil and criminal courts, and you can sue for the infringement against the violators, and you can claim the damages about the loss you got by virtue of the infringement of rights on the intellectual property. And to encourage the research and development, this is the most debatable subject in the present domain. Suppose, assuming for a minute, if the Covaxin and Covishield, that formula of manufacturing, if it is made open and somebody has started copying and government does not take any responsibility and the person is not able to protect his rights, why at all somebody will go for the research and development, spending crores and billions of dollars of rupees on the investment on the research and development? Because once there is a statutory laws are powerful, the person who invents something is being protected. Under those circumstances, it will encourage the research and development to come up with the new ideas and new medicines. Now take the example of today, COVID. We have got there is no medicine for curing the COVID. It's only the controlling by virtue of the putting the vaccination, taking the vaccination to improve the antibodies and all. So likewise, if you have got a statutory regime is very strong with regard to the intellectual property rights, the people are encouraged to go for the research and development. And undoubtedly, it creates a healthy competition. All of you are seeing, because India had got only two kind of vaccines, Covaxin and Covishield, and today Moderna, Sputnik, and many other companies have started coming into the India and to sell their products and to make the money out of it. And when the competition is there, the rates will come down. And see the example of the many people, how the people are dying. Of course, leaving aside the oxygen, the remdesivir drug today, people have a shortage of that. And the registration of the intellectual property rights also encourage the scientific community, because once you are registered and once the government recognizes your rights on the invention, and they will be in safe hands so that they can fight against the infringers. And there are mechanisms to approach the courts to for protection of your rights. So these are the benefits of the registration. And now slowly getting into the subject. So what are the basic intellectual property rights? Ladies and gentlemen, these are the 6 basic intellectual property rights. One is the trademarks, and second one is the patents, copyrights, designs, geographical indications, and trade secrets. And if you look into this, because for the easy understanding, I just presented a Sprite bottle just behind the screen. I think I'm sure you are able to see that. Now, I want to put it in a nutshell, in very easy method of understanding this subject is every product has got all the intellectual property rights imbibed in that. For example, take the Sprite bottle. On the Sprite bottle, the word SPRITE, which designates a trademark. The name by which the product is being called as here it is the Sprite, SPRITE, is called as a trademark. And interestingly, the trademark can be registered as a word per se, as a word SPRITE, and also the right of style of writing of the Sprite can also be registered under trademark, and also the label over which it can also be registered under a trademark. Now, the trademark, precisely, it identifies the product under the particular name to get itself distinctive to be called as a product of particular entity. The trademark it can be a service mark. Service mark covers for those which are not for the goods. And this trademark is called as a Sprite here. And the patent. Now, if you take out that liquid inside the bottle, if someone, without putting the Sprite bottle in front of you in the transparent glass, if they give this product to you in the white transparent product, and similar products of the Limca and 7-Up or several other products of the same category, if they don't put the bottle in front of you, if you put it in the transparent glass and offer you to drink, by drinking that, you can very well say that the X product is a Sprite and Y product is a Limca, Z product is a 7-Up. Because the ingredient of the product, the combination of the several ingredients of the product, and which is the end product, which is in the bottle of the Sprite, that is nothing but an invention. And here the slight similarity because of the trade secret and the patents. Today, as of today, Coca-Cola has not patented its product. The benefit of patent is you get the statutory right over the product, but the moment you file an application before the patent office, it comes into your public domain, and after 20 years, anyone can copy this and you can't have your absolute rights over that. You have got exclusive rights over that particular patent invention from the date of your application to till 20 years. But as long as you keep that secret of mixing the different ingredients to get that taste, it is as simple as such, it is your trade secret. So accordingly, many companies like Coca-Cola, especially the cold drinks companies, have not gone for the registration of their invention of the patent over this intellectual property right, and it is still remains as a trade secret. As long as you keep this secret, but you don't have any statutory rights to get protection once somebody copies this product. And next, coming to the copyrights. And here the copyright, if I present a label which is wrapped up over the Sprite bottle without the name of Sprite, and by seeing the label, you can very well say that this is a Sprite bottle, Sprite, label which belongs to the Sprite product. How you are able to identify? If you take up the example of the Britannia biscuits, Britannia Mary biscuits. Now, Britannia Mary biscuits, the white, that milk chilling out and the wheat seeds exhibited on this label. And even somebody doesn't write the Britannia and Mary over that, if the label is shown to the person, he or she will still say that this is a Mary biscuit wrapper, because this is appealable to eye. The artistic features over the label, that comes under a copyright. Of course, copyright is a bundle of rights. There are multiple rights, not only the copyrights, the label, because there is a literature, cinematography, film that we'll be discussing in later stages. But to understand this subject at this stage, the kind of intellectual property rights, the copyrights with regard to Sprite product, even the Sprite is not written, it is taken out. If the label is shown to the individuals or persons, they identify these products because of the copyright artistic features of the label. And ladies and gentlemen, suppose you've got a wonderful trademark, very easy to pronounce, and it's very good. And patented product inside this bottle is still very good. And copyright is artistic features of the label is also very good. But all these intellectual property rights are just to promote your product and to make the money out of it. But if you don't have a good design to this product, design of the bottle, I'm sure it will be a negative side. Now, designs is the most fascinating and one of the most important intellectual property rights, for the reason because if I don't write Sprite, if I don't put a label, if I don't put anything in the bottle, but if I show you the green bottle with the dots, you identify this product as a design. The design which is, external features of the product which is being containing inside it, that is nothing but the design. It is specifically governed by one of the, separate act by the Design Act. So that's how to understand this subject, you take any product, you take a pen. The name of the pen is a trademark. The way it is writing and the combination of all this internal mechanism of that is a patent. And the copyright is the way the name is written or the sort of, logos are put up on the pen. And if the design of the pen, many people get fascinated with most of the intellectual, why is I say this, design is the most important intellectual property right? Because people get the first impression by looking at external beauty. That's how many people see the external beauty, get married, and when they understand the patent inside it, they get divorced for it. Anyhow, now there's deviation from the subject, but now the design is one of the most important intellectual property rights. And next is coming to the geographical indications. And please try to understand geographical indications is also a kind of trademark. The geographical indication is name of the product which is identified by the topography and particular area. One of the most of the best examples are basmati rice, Kolhapuri chappal, Darjeeling tea, Alphonsus mangoes, Banaras silk, or Pochampalli saris. Likewise, Hyderabad biryani, Halim. These are all the names, nothing but the trademarks, which are identified by its topography. And one of the important differentiation between the trademark and geographical indications is that geographical indications can only be registered on the name of the associations formed. And unlike trademarks, the geographical indications cannot be assigned or sold out. So like Tirupati Laddu is also geographical indication that is in the litigation now. But these are all the many product, the geographical indication. It is a very, because India is one of the Darjeeling tea I've seen when I went to United States of America. The Darjeeling tea, because it is registered under geographical indications, the rate for if the 1 kg of Darjeeling tea in India is, if it is 1,000 rupees, it was costing 10,000 rupees in United States of America. So that's how the statutory benefits, once you get the registration under the particular act, you get the benefit for those intellectual property rights which are being registered. And next is the trade secret. Already I told you, because the patents, if it is registered, it comes into your public domain. If you maintain that secrecy, if you don't go for the registration, it is a trade secret. And one of the best example, because the methodology of running the institutions or methodology of running the companies, for example, take the Dhirubhai Ambani is not a product of Harvard Business Schools or Indian Institute of Management. But the way he has built up an empire today, everyone know, because his sons are now the billionaires and the most richest persons in the world. The way the organization being run by them, it is also one of the trade secret. Now, next to coming to the point, some of the symbols which are shown is the TM indicates the trademark, SM indicates the service mark. We'll discuss when that particular trademark slides comes over that. And R stands for once the mark is registered, if R is put at the right side top corner of the brand name, it means indicated as it is a registered trademark. If somebody is using the R without registration, it is a punishable offense under the criminal law as well as the Trademarks Act 1999. C stands for the copyright registration. Now, out of this all intellectual property rights, trademark is one such intellectual property right. You can keep it with you as long as you renew it for every 10 years. Except trademarks, rest all I got the limited life period. That is patents, if the registration of the patent invention is done, and after 20 years, it becomes a public domain. After 20 years, anyone can use without the express permission of the person who has invented that. And there is something like value added patents, and although that is not a subject matter to discuss here, but we'll discuss on that. And copyrights is the creation of any artistic features or cinematography, film, music rights. All these are having the life of 60 years from the date of its creation. And with regard to the literature, like J.K. Rowling has written the book Harry Potter, and till her life she enjoys the rights over that. And after her death, 60 years from the date of the death of the author is the life of the copyright over the literature, and her legal heirs can also enjoy this property for next 60 years by way of royalty. And imagine, ladies and gentlemen, today she is the richest woman. She is richer than Queen Elizabeth. And only thing she did is she has written a book and left it in the market, the way she is getting the royalty. That's how in India and all through the world now, incubations and startups, these things have become crazy, because people are inventing something, and by today, the Ola, Swiggy, Zomato, Amazon, how famous these are. A small idea which has erupted into such a big entity, and the results you are seeing that. And these are all the basic intellectual property rights. And slowly we are getting into the subject, because what are the international organizations which are governing this intellectual property rights? One of the organization is the World Intellectual Property Organization. He is one of the wing of the United Nations, and which is one of the prime authority, and which is based at Geneva. It has got 193 members. And this having a control and checking today World Health Organization is controlling all this pandemic of COVID and giving the guiding principles to all the world to what to do and what not. Accordingly, WIPO has got its control over almost 193 countries, and bringing the policies with regard to any developments all through the world with regard to various aspects of intellectual property rights. And its mission is to lead the development of a balanced and effective international IP system that enables the innovation and creativity for the benefit of all. And rest all other organizations like AIPPA is it's not a statutory obligate body, but this is an institution which has been constituted in 1897. And I am one of the vice member for the AIPPA for Indian group. And this is one of the most important organization which makes the policies in view of all of you know that law is dynamic. Once I said there's a technology, nobody might have thought about the intellectual property rights so deep at earlier point of time. Nobody might have thought of the cyber laws, because only Indian Penal Code was existing, never thought of the evolution of the computers. and internet, Wi-Fi, and hacking, all these issues. Once this kind of developments happens, now the law is dynamic, law has to be framed to control the hacking and all those things. That's how the cyber laws have come up. So accordingly, AIPPA also discuss about the burning issues all through the world. Some of the evolution of the jurisprudence has been discussed in the AIPPA conferences. And these AIPPA, this is nothing but the French acronym, which stands for the International Association for Protection of Intellectual Property Rights. And it discussed the policies and the policy decision which are framed in the conference of the AIPPI are being adopted by the famous organization like World Intellectual Property Organization or USPTO or European Union of Patents. Likewise, many other Asian other countries have like APA. And these are the prime organization. And unfortunately, now India, we don't have any such organizations. But recently, we have been coming up the seminars and conferences are being conducted by World Intellectual Property Forum and Global Intellectual Property Conference, etc. Accordingly, this AIPPA is based again. It is in Switzerland and Zurich. And another important organization is INTA. One is International Trademarks Association, which is being constituted in 1878. And every year it conducts the conference and seminar. You will be shocked to know that there will be a gathering of almost 11,000 advocates at one place every year to discussing the policy changes and discussing the evolution of the changes in the law in every countries. The reason because the intellectual property rights is a universal and it is a global. If you want to file an application for the registration of the particular brand name in United States of America, it has to go undergo as per the local procedure and per the laws of that country. Accordingly, because now the brands are universal, so once it is being registered and once the brands are any product is being used in particular country, litigations do happen, and that's how the gathering of the international all through the advocates gathering at one place and discussing about the global scenario about the different laws in different countries. This INTA is one of the prime organization discussing about it deals only with the trademarks. Now, likewise, there is a Madrid Protocol. All of you are aware. Recently, there was an issue with the discussion with regard to this. Can the application of the trademark registration file in all the countries at one go? Not exactly, but the Madrid Protocol discuss about this. And likewise, the Hague, the international design system is being discussed at that place. And Lisbon is the place where international system of geographical indications is discussed. And next is the Budapest, the international microorganism deposit system, etc. Likewise, there is a PCT, the Patent Cooperation Treaty, which is established and has got its office at Washington. And in 1978, it is formed. And the filing of patent application in the various domains, international applications, that discuss about that. So these are the international organizations which have got the close network of the governing and formulating the policies for the regulation of the intellectual property rights all through the world. And it is now the China is dominating in this domain also because there are thousands of applications and every year it has got the registration of the thousands of patents in that inventors of that country because it is educating more of such about that inventions and going for the registrations and the value of intellectual property rights. And next is the domain is the USA and India. It is slowly coming up subject. And by virtue of these workshops and seminars, people will get more awareness. And I'm sure in the coming days, this is one of the most burning subject in the all through the globally. Now, coming to these, we have been discussing about the international laws because I'm just getting into the subject because now all of you are aware that because everything is governed by the law. As I told you, because there are three sources of law. One is the law made by the parliament, which is in terms of acts, what we call as the act. And second one is the judicial precedents. Supreme Court pronounces any judgment that is whether it is right or wrong, because all it is binding on all the courts in India and everyone has to follow it. And third important source is, as I told, the customs. And let us not get into that. But now the question is, now these are the acts which governs when you discuss about the Trademarks Act 1999, and there was a act in 1940, then Trade and Merchandise in 1958, and then in the 1999 the old act is repealed and the Trademarks Act 1999 has brought up in terms of the TRIPS agreement, India being the signatory of that, wherein rules are again changed in the year 2017 and 2020 to bring the changes in view of the developments in this particular domain of the field. Now, likewise, earlier only trademarks were to be registered in the Trademarks Act 99 is framed. Then the concept of, well-known trademarks, service marks, and all these things we'll discuss in later slides. So as lies dynamic, any change coming in the society, it will be amended and implemented in the existing act. Likewise, the Patents Act 1970, which is being amended in 2005, and it governs about the registration of the patents and the regulation and how to give the compulsory licensing. All these issues are discussed in the Patents Act. And accordingly, one of the oldest acts so far is one of the robust act, we can call it as the Copyright Act 1957. And there were not great changes of amendments of such as of now. Now, next is geographical indications of goods, Registration and Protection Act 1999. It is Act 48 of 1999, call it as. This covers the registration of the geographical indications and its effect on this. And another issue of the Design Act 2000, where the registration of the designs of the end product, which can be taken up governing as per the governing laws of the Design Act 2000. And there is one another act, which is Protection of Plant Varieties and Farmers' Rights Act 2001. And ladies and gentlemen, just I want to have a stretch on this subject for some the reason on this, because there is another which is well known in India, especially they called as a traditional knowledge. Now, traditional knowledge, there are varied questions on this subject, because can the traditional knowledge be registered as a patent? There is no law governing the registration of the traditional knowledge of such. And in India, there are the thousands and lakhs of the traditional knowledge. People are aware, especially when I quote, I don't know how many people know about the Hyderabad in the Mrugasare Karthi. It's the rainy season. There is the brothers of the family by name Vattini brothers, Vattini Gouds. They give a fish medicine for the curing of asthma. Now, you believe there will be lakhs of people who are coming to Hyderabad on that particular day. 2 days it will be there, and the medicine is insected into the small fish, and that fish is pushed into your stomach, and by that the asthma is being cured. Now, what is the validity of that? If you come into because today I quoted the example of Anandaya, who is giving the medicine for the COVID, seeing the success, 10,000 people gathered before his house, and police were not able to control that crowd. Now, this is the traditional knowledge, but unfortunately in India, because this traditional knowledge is not being properly protected. Now the government has come with the traditional TK, traditional knowledge. The digital library has started, because widely we call it TKDL, and documenting the traditional knowledge. This how when India, because somebody has filed a patent for the turmeric in US, and when India, because of the documentation we had with regard to the validity of and the use of the turmeric in India. By that, when we contested or raised an objection for the turmeric patent in the United States of America, the USPTO has revoked the turmeric patent given to that citizen, and just because of the involvement of the Indian government, and today the government is so careful, because a separate department by name UoH-IIC is being constituted, and all of you know what UoH stands for. UoH for Ayurveda, Yoga, Unani, Siddha, and Homeo. What is the acronym of UoH? So likewise, so there is also another one such incident which has happened. There is a person who has filed an application for the neem patent in European Union Patent Office. When India has objected with the proper documentation, then the patent granted to that person is being revoked. So that's how, because the documentation is, again, I'm repeatedly telling on this aspect, because Albert Einstein rightly said, you may be knowing something, but if you don't exhibit or demonstrate what you know, then it is of no use. So accordingly, Indian government is now at least documenting the traditional knowledge, because if you go to villages, I think hardly in that, if you go to tribals, they never use allopathic medicines. They have got the medicines which they use, maybe of Unani or maybe of Ayurvedic or conventional medicines they use, and that cures many things. But there is no validity under the law. So unless government rescue those people, it doesn't happen. Now, next coming to that is, now, this is we are now getting into the each and every subject in nutshell, because I will not be going very deeper into this, because once I get in deeper into this, probably it is very difficult for the next speakers to talk elaborately on this. And one of the most important aspect of the trademarks is the products are identified on the name. It is as simple as such. And if you want to really see the definition of it, it is a visual symbol or sign in the form of a word, device, or label, and means of identifications which enables the traders to make their goods or services readily distinguishable from the similar goods. For example, Coca-Cola. All of you know, because anything you put it in the bottle, still people say it is a Coca-Cola. As we know, because when you go to unfortunately in India, the vegetables which are to be taken care of and they are sold on the footpath, and the shoes which are sold in the air-conditioned shops. And take care, for example, if you go to a Nike shop, if you purchase a Nike shoes in the showroom, it will be costing 10,000 rupees. Just take out that label, put it, and just in front of the shop, you put it on the footpath and sell it. And people hardly purchase it for 500 rupees or 1,000 rupees. And what is that? Which makes the difference? And I was told, because when the Bill Clinton came to Hyderabad, the then Chief Minister of Chandrababu Naidu has gifted the bunch of T-shirts, which he is very fond of. And particular brand which is manufacturing those T-shirts in United States of America, you'll be shocking to know that those T-shirts are manufactured in Hyderabad in a particular place called Balanagar. And these are exported and being put a brand over that and sell it in other countries of exorbitant rates. So brand is so powerful. And if I want to tell, because some of the very, very famous brands is just exhibited on the screen is Xerox. And today the company Xerox itself is in serious trouble. The reason, because it lost its identity. Now people go, I don't think anybody can show any shop name which is displayed as a photocopying shop. Everybody put the name of the shop is a Xerox. Xerox is a machine which manufactures and demonstrates the functionality of photocopying of the written matter. And nobody says, because even the company by Modi gives that mechanism, people go to the shop and say that give Modi Xerox. Nothing like Modi Xerox. Like you are going and purchasing a Dalda. Any other product of similar product of any other brand name, people say give me so and so Dalda. So these are because these products have become synonym to that kind of operation of the product. So because the brand, once it becomes famous, it becomes synonym to that. And accordingly, when you go to the villages, and if somebody wants to any blue cake for washing soaps, any company it could be, people say that give me so and so Rin or Surf or Colgate toothpaste. These are the brands, because that's how the companies invest crores of rupees on the promotion. Maybe by famous cricketers, maybe film actors. They advertise the product, and the product cost maybe 2 rupees, and the cost of advertisement could be 6 rupees, and they sell the product at the cost of 10 rupees on commission. And the actual product is cost worth of 2 rupees. That's how exactly the government is promoting the generic drugs. I was shocked to see that, because one of the program I saw where Amir Khan was in the program, it was Satyameva Jayate program. I was told that a manufacturing of a drug is 2 rupees, but the drug is being sold by the famous companies for the cost of 100 rupees. See kind of profits they get it. Because we people are crazy of the brands. And that's how because the companies invest so much of money on the intellectual property rights, maybe a patents, maybe a trademarks, and they create a brand. Of course, they take a lot of pain to promote this brand name. So accordingly, now the question is, when somebody started imitating, the multinational companies will not hesitate to spend crores of rupees on the litigation to suppress the small companies. Of course, we have got an abundant experience in the dealing with kind of litigations, but it's not the matter to discuss over here. But this is the kind of, if you understand this subject well, now especially what are the precautions to be taken when the trademark is to be registered. Now, first and foremost important aspect is the distinctiveness. A brand which is to be taken up for the registration shall be distinctive. It cannot be descriptive. And there cannot be any similarities. In the serial number 1, 2, 3, all these things are covered. The issue is that when the mark should be coined, in the sense, suppose if you have got a partnership firm, if you want to launch one of the product or one of the firm name, you pick up the alphabets of the one partner 2 alphabets and another partner 2 alphabets, or somebody in your name, some of the alphabets, you coin the name and you put it in the market, you launch it and go for the registration. There cannot be any oppositions. But if you copy somebody's mark, if somebody, for example, Sony name, if you take it as, if you instead of SONY, if you want to adopt the name Sony, SONI, or SOPI, something like that, then it is an imitation. There is a deceptive similarity. And ladies and gentlemen, one of the most important brand is the Jeep. I remember because Any kind of vehicle, of course, Jeep again entered into India because it was missing for a long time in the Indian market. Now, even Mahindra manufactures the kind of vehicle, that kind of, the features of the vehicle of Jeep. But still, people say that Mahindra Jeep. There is nothing like Jeep of Mahindra Jeep. Mahindra has got its own version of the vehicle. So likewise, these are some of the famous brands, because once brand becomes famous, people will started copying, and else the people will identify that particular any of the product of that nature with that name. That is how the brand becomes famous. And it should be distinctive, it should be coined, and it should not be descriptive. It should not be descriptive of any of the names and the types of, there cannot be any similarity. Similarity doesn't mean that mark should be identical, and mark should not be of deceptive similar, confusingly similar, and there should not be any kind of similarity. So then that mark will sustain in the market. And generic terms, there is always possibility of the picking of the generic names, names which are common. For example, if you take something like that hotel name on your son's name or your daughter's name, or putting the sum of the name which is very generic, Sri Krishna Jewelers or Sri Krishna, or some god name or some name which is very familiar, or whichever is the generic names. And when I say the generic names which regard to pharmaceutical products, now for example, there is something like in non-adoption of the international non-proprietary names. For example, if the ingredient of the drug itself is taken as the registration of the trademark, that is prohibited. For example, diclofenac sodium. Every doctor knows diclofenac sodium can be given for the painkiller. You can't pick up the name of diclovin, diclotin, diclosin, or anything of that nature of the ingredient of the product itself. That's how these are the. Then once you pick up those names, there is every scope for the litigation. There is a particular section 17 in the Trademarks Act covers, where the mark should be considered as a whole, and the marks which are generic in nature are common to trade. When you pick it up, there is every scope of litigation, and those marks cannot get the absolute rights. And also sometimes a disclaimer is being given by the Register of Trademarks when the trademark is being registered. And there's something like Names and Emblems Act. The names which like Mahatma, Krishna, Buddha, Bharat, these are the names. There are the prescribed names in the Names and Emblems Act. Those names cannot be taken up for the registration. And next is the point of service marks. When the trademark registration happens, there are, as we discussed in the earlier slides about the NICE agreement, the marks which are falling under the category of class 1 to class 35, these are called as trademarks, and 36 to 45 are called as service marks. For example, hospital names, insurance agencies, and real estate business, and names of the law firms or names of the institutions. These are all service marks. These are not into trading. Effect of the registration is same, but those are called service marks, and the marks which are falling under class 1 to 35 classification of the goods are considered as the trademarks. There is a collective mark, and where if you go to particular shop, you get the varied products like different brands at one place. If you go to Shopper Stop, it is a name of the shop itself is where you get the many brands inside the shop is something like collective mark. Like Interflora is one of the shop where you get all kinds of flowers in United States, which is called example Interflora. And there is another one is like certification mark, like you have seen some of the wool mark, it is displayed there. And for the gold, some of the parameters, AGMARK. For the food products, ISI, now Indian Bureau Standard, it is that is the kind of certification given by the government to identify the products for its quality, is a certification mark by the government. And another thing is which I want to add here is the geographical indication, even though it is a separate intellectual property rights, but it is also a kind of trademark, but it can be registered on the name of associations for identification of the products by particular domain of or domain or area. Now, all of you know, because as I already explained, because the value of the Coca-Cola, Microsoft, and IBM exceeds the name of if you want to purchase the brand name, it is $50 billion each. And the Apple brand is $100 billion, as it was in the last year newspaper news. I don't know what could be the present value of that brand, because all of you know, because when the Apple launches any of its product, and the people are crazy and they wait in the line to purchase the product on first day. I don't know what. And second issue, because Apple doesn't give any of this accessories also, because it is costing much more than some of the cell phones you purchase and still people are crazy on the Apple, because once the brand has got its value, and of course you have to maintain that clarity and the quality also, then that brand becomes famous and fetches the more money to the government. Now, what is the branding? First of all, when we are discussing about the trademarks now, branding is because when you coin a name to a particular product, now there are the different kind of registrations which you can give for the trademark. One is the word per se. When we discussed about the Sprite, the word SPRIT, simple typing of the word when you go for the registration of this word per se. And logo. Normally every company like Tata, you pick it up, or you go to Reliance or anything, it has got a separate logo. A logo can be registered separately. A word per se can also be registered separately. And under the Trademark Act, the label can also be registered. The label is, which is displays the artistic features of that, can be registered separately. Now, see, when likewise, device is a combination of the many elements and characters, like what you call word per se or logo or combination thereon, or there could be a punchline also. Taglines and punchlines can also be separately registered. And cumulative of all these, if you can register as a device mark, which can be called as a composite marker device. And as per the 2017 rules amended by the government of India, the new concept of the sound marks and smell marks have come. And if you remember, very interestingly, because some of the sound marks registered in India are especially Yahoo Yodel. When the Yahoo, the kind of advertisement do something like Yahoo, a sound which has comes out, that is being registered as a sound mark. And likewise, you saw ICICI Bank, jingle of ICICI Bank, which calls that chick, what is that, din chick, something like that, some sort of music it gives. And if you remember, because when you old people, when they see of the Doordarshan, when the Doordarshan starts, it gives a typical music that can also be registered as a sound mark. And also Akashvani has got the typical type of, in the first time it comes into the news program and all, it gives a typical music. Likewise, internationally, there is a Lion Roar of MGM, a film entity, that is also registered. And the Tarjon L and sound of Harley Davidson bike, it has got the typical. Now, if you see the Bullet bike, Bullet bike has a typical type of beating of that is also, these are all the sound marks which can be registered. But and also there is something like Nokia tune, also something like tin, something like that. It has got a typical music. These are all the sound marks. And when the matter comes to the smell marks, and to my knowledge, because in India, I don't think the smell marks have not picked up so seriously, but smell marks can also be registered. And in UK, a tire company of Sumitomo Rubber registered for rosy fragrance of the vehicle tires. So now this evolution of the jurisprudence is sound marks and smell marks also can be registered. And when I said about the coining of the brand name with the distinctiveness, what are the precautions to be taken is because one is the market search. First of all, any entity is going to launch. See now, for example, take the example of COVID. Now, most of the companies, unfortunately in India, the brand name picked up is they want to identify this particular drug name by the name COVID, something like Covishield, Covaxin, or Covino, Coviril, something like that. Now, recently that yesterday I heard in the newspaper that self-testing kit, also where the word COVID is they want to incorporate. And today's newspaper DRDO has also come out with a similar concept area, also word COVID. They want to be put a part of this, identification of the drug or to that particular disease or whatever the name of the, that they want to put it is. Because you had to do a lot of market search before coining a brand name, especially most of the litigations are in the pharmaceutical industry. First of all, you have to see that in the market, a similar kind of names are not in existence, and any kind of similarity will invite a litigation. And unfortunately, this is a very costly litigation of the intellectual property rights in India or everywhere all through the world, because multinational companies, they invent billions of dollars on inventing some product and somebody is violating. And just for the reason of somebody is violating, they can't keep quiet and they will spend any amount on the litigation to give you effective representation in the courts and to win the cases under the domain of, the statutes. And we all discuss in the patent subject when it comes compulsory licensing and all. And then there is a domain of nic.ip.in, the public domain, where the trademark search can be taken up before launching a product. Randomly, you can go for a search of the trademark, whether this particular trademark is available available for the registration or not. And this is one of the important aspects, because well-known trademark to be taken into consideration. The reason, because suppose today Tata is not into pharmaceutical business, and the goods are classified into up to 45 classes. Can any other person can go for the registration of the name Tata for the goods in which the Tata is not into that? The answer is no. Because once any of those marks which have got the international reputation and huge volumes of sales network and whose goodwill and reputation very high, those marks are considered as a well-known trademark. And those marks cannot be taken up for any other brand. For example, Sony is into electronic business only. It doesn't mean that today, because Sony is not into pharmaceutical business, can anybody use the name Sony for pharmaceutical tablet name or something like that? No. And one of the best example I want to tell you, because I did my PhD in law, I am Dr. Reddy. And today I can't put my name of the firm as a Dr. Reddy firm, because the Dr. Reddy is considered a well-known trademark, which is into pharmaceutical business, very famous. So these concept of evolution of the law has come up because the amendments have taken place, and this well-known trademark concept is added. There are some of the names which generic names, as per the Supreme Court judgments, which have stated that when particular brand name, by virtue of its usage in the market, attains the secondary meaning, those brands can be accepted even though those are generic. So likewise, there are famous judgments like Inadu and several other judgments, and that's how the jurisprudence has come up in the market. Now, this is what about the branding. Now, just because I'm not going deeper into this particular slide, because my next speakers could be definitely covering on this topic. And what are just in nutshell about the stages of registration, equally when it is for trademark, but precisely this can be taken up for all other intellectual property rights also. Now, when the registration of the trademarks do happen, now, first of all, the entity who is coining the trademark, the search need to be carried out by the trademark website, whether this mark can be taken up or not, or to know whether any that kind of similar marks and deceptively similar or confusingly similar or phonetically similar marks are existing in the market, the trademark search can be carried out. And once it is satisfied that this mark can be taken up, you have to identify the goods, and you have to identify in which class it falls, and you should be sure about under whose name you are going to file the application. These are very, very important criteria. And I'm not going to discuss in detail what is the fees and all, how to file an application, because I will be definitely jumping into the domain of other speakers. No. And next is the application to be filed before the concerned registry. There are total 5 registries in India, and every area's registry jurisdiction and domain of area because being defined. If it is in South India, the application should be filed at the trademark registry Chennai, and if it is any other, because the particular application can be filed 5 registries in India. Once the application is filed, the examiners who are sitting at the trademark office, they will be going through the application meticulously, and there are 2 sections, which are one is the section 9 of absolute grounds for refusal, and section 11 is the relative grounds for refusal. Under these 2 categories, in addition to other section 13 of international national non-proprietary names, or if it is the Names and Emblems Act, the objection would be raised by the examiner whether mark can be registered or not. That's the reason I said, because before coining the name, mark should be coined, it should be distinctive. And if none of the marks in the examination report comparing to the search of the trademark from the trademark website is not matching with that particular brand name, it will directly go to the registration. But most of the cases, because it is very difficult to get the brand names in the especially pharma industry, the examination report will be issued by the registry, the reasons for refusal. Then it should be answered by the applicant or the agent or the counsel on record to say that why this mark is distinctive and how this objection can be overcome. And upon the same, there will be, if the registry is considering your objections and answers, then it will directly go for the registration. And if any clarification further needed, there could be show cause hearing where the counsel or applicant will be arguing before the learned registrar of trademarks, satisfying the registrar why this mark can be taken up for registration. If the registrar satisfies, then it will proceed for the registration of the next stage. And if not, it will be rejected. Agreed by the said order, you can go for the challenging the said order in the Intellectual Property Appellate Board, and unfortunately, and recently the Government of India is taken out that intellectual property, Intellectual Property Appellate Board, and these orders to be challenged in the respective high courts now, and there is a clarity is to be come out, and are the commercial courts of particular domain area. Now, then the mark will be published in the trademark journal. It is on the principles of natural justice. Once the mark is published in the journal, anybody in the world can object for the registration of the such trademark by anybody who is aggrieved for any reason. Not only that, because somebody is having the similar mark, he can only object. No, it can be objected by anybody, whatever the reason stipulated in the law. Once somebody opposes this brand name, but this opposition has to happen within 4 months from the date of journal publication. Once the opposition is there, then it's a kind of litigation before the quasi-judicial authority. Like somebody raises an objection, counter need to be filed, evidences have to be filed by both the parties. Then the final arguments would happen, and registrar satisfies, the opposition can be upheld or opposition can be dismissed. Accordingly, if the opposition is dismissed, the mark will go for registration. If the opposition is upheld, then the registration do not happen. And either of the aggrieved parties should have gone to IPAB in the earlier situation, but now they have to challenge before the concerned commercial courts or before the respective high courts. Now, this is looks like as simple as such, but it is the normal process of this would take at least minimum 6 to 7 months, and depends upon if the opposition is there, it will go for years together for the litigation. Now, once the registrar grants the registration of the trademark, the certificate of registration could be given, and then only you are entitled to put or in a circle at the right hand side top corner of the trademark. Now, not registered but you put or at the right side top corner is an offense, as already told. After the registration, somebody misses the bus of opposition. Now, remedy available to the person is challenging the validity of registration by way of rectification. Now, this was the domain of either registrar of trademarks, or it could have been filed before Intellectual Property Appellate Board, as it is being abolished now. Now, this may go to before commercial courts or the High Court for challenging the validity of the registration, and registration can be cancelled if there are any valid grounds in accordance with the law. Now, this is a simple process as looks like, but the registration of the trademark, definitely in the subsequent speakers would be covering in detail about the registration process. I'm sure I'm not jumped into this domain because I just give a brief idea about the overall broad view of this. Now, next, coming to the patents. Now, there is the most important subject, which is a very heavily discussed in the present domain, because many debates I have also seen, because why can't the government give the manufacturing facility of the Covishield and Covaxin to the various other companies and manufacture in bulk and give it to the public at the cheaper rates? Yes, this is something like, the people's voice versus the patent subject matter. Now, ladies and gentlemen, it is a very debatable and very sensitive subject, for the reason that because companies normally invest heavy amount of the money on the scientists, infrastructure, and R&D facilities, and especially conducting the clinical trials for the pharmaceutical product. And once somebody invents, now any invention looks very easy after being invented. And we are specially expert in the reverse engineering. Somebody invented, we break the drug and we go reverse methodology, and we do the same thing where we are infringing the rights of the real owners. So that is the scope, because where the government has taken, as a balancing approach before the satisfying the inventors and at the same time meeting the requirement of the people. Now, under these circumstances in India, so far only one such compulsory licensing is being given to the NATCO for the manufacturing of cancer drug. That is, I think it is an Naxavar, and where the Bayer, who is the patentee holder, was able to provide the drug at the cost of 2.8 lakhs per month for almost 120 tablets. Whereas the NATCO has come with the proposal that they can manufacture this drug 8,000 to 9,000 rupees, very same drug, 120 tablets per month. And first in Indian history, it has created ripples all through the world. The then controller Kurian has granted the compulsory license, and finally matter went to Supreme Court, and it is being decided that every sale of Naxavar of the buyer, which is for which patent is there, 6% of the sales volume to be paid to the as a royalty to the Naxavar, that is a buyer by NATCO. So now there are the situations, because this is a pandemic situation, this is the government may also come out with in the coming days. We may hear the many news about the compulsory licensing, and it's again subject matter of discussion. There are interpretation of laws, why to be given, why not to be given, and all those things. Anyhow, now we are getting into the subject of the patents. Patent is nothing but it's a new idea of particular process of manufacture, producer, or discovered by human skill. Intellectual property rights itself is a human skill, and it's a invention. Now, one of the most important aspects, there is a very quite similarity with regard to the two. One is a patent, invention, and the discovery. And discovery is not an invention. And put it in a very simple way, because Vasco da Gama has not invented India. Vasco da Gama has discovered India. So because which is already existing in nature, or which is already known to the public, and that cannot be called as a invention. Invention, there are the parameters for what to be called as invention, and Act also very specifically defines. It is a Patents Act 1970 clearly discusses about that. And it is a right given to the inventor to enjoy the exclusive rights of his invention. When I say the exclusive rights, for next 20 years from the date of the making of an application, the patentee is the absolute right owner, and who can exploit it the way he wants it, subject to restrictions by the government if it is required for the public domain, in the larger interest of the public by way of compulsory licensing. And it is a kind of privilege of making, manufacturing, and selling or using an invention, also a right to authorize others to do so. Right to authorize others is by way of it's not assignment, it's a licensing, or giving the set of franchisee. And there are restrictions, some of the leverages given by the government, where if somebody wants to use it for R&D purpose in small quantity, they can use it, but not for the commercial exploitation of the patent for which this particular product is registered on the name of a particular person. Because there are the important criteria for what are the conditions of the patentability. A patent invention should be new, and it must be novel. When it is new, it's not a discovery, as we discussed it, because which is existing in the nature, it cannot be a patent. But the available products in the nature in terms of discovery, by adding combination of those 1 or 2 or 3 or different other products, if you get a new product which is having the patentable subject matter and industrially applicable, then that can be called as a patent. So first of all, it should be new invention, and it should not be a discovery, and it must consist of patentable subject matter, because there are the parameters. Many people, because every application you file before the patent office is not registrable. Unfortunately, in India, of course, it is a very pathetic situation, because many applications are rejected because there is no subject matter of the patent and invention at all. We should have a wide applicability of the industrial applicable, and it must be new and novel, and very important, because it is not already existing in the market, and you have to demonstrate by way of specifications. And the claims are very important, because what exactly you are claiming. Today you got a pen to write, but if you come out with a different version of the pen, which is maybe the existing patent is there on the pen, but if the product is something new and novel other than the existing product, then you can go for the registration. There are also something like utility models and software patents. When I discussed about the copyright, because the software language which you create is not patentable in India, but it can be registered as a copyright, under copyright. But if you go to United States, the software writing, that software language is considered as a patentable subject matter in USA. Likewise, there are many things which cannot be patented also, like I think the next slide covers on that. So what are those things which cannot be covered as a patent? Now today, because the COVID pandemic situation, many people are going for the RT-PCR test and other tests, and all those things are those the diagnostic methods of treatment for humans or animals, or diagnostic methods practiced on humans and animals cannot be patented. And also discovery of materials or substances already existing in nature. So as I told, because anything which is already existing in nature cannot be patentable, and scientific theories or mathematical methods are also not patentable. And there is another thing is plant or animal varieties are essentially biological processes to produce such plant or animal varieties other than microbiological processes are also not patentable. And schemes, rules, and methods of doing the business. For example, Amway, a chain network. One sell the product to 4, 4 sell to the 16, 16 sell to the 32, something like that. At 64, and those kind of business methodologies cannot be patentable. And method of treatment for humans or animals, and these are in the public interest, because that one another thing is the agriculture method of agriculture or horticulture is not patentable. And any invention which is frivolous, of course, it is by default it is cannot be patentable. And invention relating to the atomic energy, any invention which against the public interest and destruction of the public cannot be patentable. And it's a very wide debatable subject, and there are what could be patented, what not be patented. That will be elaborately discussed with the speakers in the next slides and next sessions. And I'm not getting it deeper into this subject then. Now, coming out of the patent, then coming to the subject of copyright. Copyright is a bundle of rights, and it's very interesting because especially there are many associations which are formed to protect the independent rights of some of the artists. Anyhow, we'll come on to that. Now, what is the copyright? Why it is multiple rights and bundle of rights? Because copyright can be involved with respect to literary in the sense books which is written, or any sort of software language it is being created, anything you put into writing, you compile it and you go for the registration as under copyright. And registration of the copyright gives her 60 years plus 60 years plus after the death of the author in terms of literary and dramatic, musical and artistic works, and cinematograph, film, sound recordings and computer databases. And really some of the interesting aspects of the copyright is because you might have seen the litigation with regards to Three Idiots and Bahubali and several other films. In one of the film, the Devanand, Darling film, he said that he is the owner of the movie because he is the person who is the hero in the movie and all. Then court said no. The producer who is created, who has invested on this, and the cumulative effect of a performance of several artists, and it is a movie, and the producer is the owner of the movie. There are several judgments and all. And I especially remember in our domain, because there is a picture has come, Mr. Nokia. And somebody has challenged in the Delhi High Court because Nokia has filed a case saying that their name is being used in the film as a Mr. Nokia. And it has ended up in changing the name of the movie as Mr. Nukaya. Nukaya in Telugu name, one of the person's name. So likewise, many people, you are aware of the movie Padmavati. The name is changed to Padmavat or something like that. So these are the kind of litigations, because especially the film industry is the most unorganized sector, and the documentation is very poor. And in all the intellectual property rights, the documentation is poor, and it is a scope for litigations. And now these are the things which are the subject matter of the copyright, and it also includes the neighboring rights granted to protect the performers, producers of phonograms, etc. And the question arises: somebody sings a song, whether he is the owner of the song? No, because the music director, the cumulative effect of the singing of a song with the music background and everybody tablaist and everybody plays, and the end result of the product which comes as a CD is called as the owner is the film or the music director. Accordingly, the jurisprudence of the new concept of the law has come in the John Doe orders. We will be discussing the subsequent slides. What are the kind of orders the courts can grant in the intellectual property rights, and these kind of orders you never knew in the regular practice of the law. And this domain of the registration of the copyright subject matter is governed by the Copyright Act 1957. And Copyright Act normally creates the exclusive right to the author to produce, reproduce, publish, perform his or her work in all ways known as possible. Now, especially because in the 31st December bonanza people, because many of the 5-star hotels conduct the events, and in the night 12 o'clock they keep running the music of the several music singers and all those things, and most of the performers, artist associations, which they file cases in the various courts saying that they are not taken the permission to run this music. Without the permission, then it comes to infringement, and many suits get filed in the courts and the courts grant the injunction, and immediately that whole program comes to a halt because they have to pay royalty to those music recordings. Now, normally what happens, famous singers and famous music producers, they go for the registration of copyright. There are many performers who are the singers, who are the street singers or folk singers. They don't know about this laws and all. So there are the associations which are formed, copyright protection associates, and these individual artists get enrolled with that particular association. That arts association protects the rights of those independent performers, paying some royalty, and those organizations keep filing the cases. If you conduct a small office party also, if you run a music, or if you run a some sort of film, or if you run a music without the permission of their respective individual singers, then it amounts to a violation of your rights. And there is something like doctrine of fair use, and this is one of the famous judgment of the Delhi High Court with regard to Xerox shop at Jawaharlal Nehru University. Now, if any recording, if pick up some sort of one paragraph of the somebody literature of the book and pick up and use it for commercial purpose, then it amounts to violation of the rights of the copyright. But if you pick up that paragraph and use it for your personal use or for academic session or to teach someone, then it does not amount to the copyright violation. That is the doctrine of fair use. Anyhow, these are all things can be discussed in the subsequent speakers in the domain of subject. And next is what are the which can be copyrighted. Already we discussed about the musical work can be patented, artistic work can be patented, a literary work, books and periodicals, and the lectures, plays, maps, art, etc. Even the slide which I prepared to present you people to about my subject, this subject study, because it is a compilation of I spent around almost 4 to 5 hours in compiling this information to teach on the slides. So this also is a copyright subject matter. Reproductions, models, photographs, computer software, cinematographic film, sound recording, and anything, because people come to the normally council, they say that they got wonderful idea and they want to go for the registration of either patent. They don't know, because immediately they say that I want to go for a patent of it. No, it cannot be. A idea converted, if the idea you can't convert into some sort of product, then it cannot fall under a patent. But if you can put that idea into a literary work and compile that all your write up into a particular book form and go for the registration of a copyright, that is the best way of doing the things to protect your invention. Normally, I already told you, because the period of copyright, the life period of the copyright is 60 years from the date of its creation with regard to all other intellectual property rights under copyright, except the literary work. Literary work is 60 years from the date of the death of the author. As long as the author is alive, he or she will enjoy the copyright over that particular product, and thereafter her or his legal heirs can enjoy that property all through their life, like real estate property by way of succession and all those things. Now, the point for consideration is that now the protection of the intellectual property rights is one of the big issue, because registration of any of the intellectual property right is not mandatory, but it gives a statutory right once to go for the registration, because in order to establish your copyright on the particular work, you may have to demonstrate many other issues. For example, if you go for a divorce, if you want to go for a divorce, to establish that you are married, you have to show the photographs of the marriage and garlands exchange, and the people attended the photographs of the people attended the function and whatnot. But if you got a single certificate of marriage registration, that one will suffice to show to the court that you are married. So that's how the benefits of the registration of any of the intellectual property rights are there, unless you go for the registration of it. See, there are many issues, because again, it's how the way you create a picture. And for example, there is a film has come as Patashala of Shahid Kapoor and all. And also there was the earlier existence of the film by Three Idiots. The way you produce the film, every film does not, even the concept is same. It was regarding discussion with regard to education system in India. But Patashala has not clicked, but Three Idiots has been successful. There may be a kind of, artist performed in that, and the story, the way it is being put up. So it is the creativity. Every director, see, the Bahubali has become such a roaring success, because to the whole world we have shown that we also can make the films of that nature. And, kind of revenue generated to the artists and the producer and the director. It was like in the similar concept, there is a film, there is a Oh My God and PK. So same are on the, some sort of on the concept of Andhavishwas, but still the way it is being taken up, some films clicks and some film may not. And that's how, because the way you present the innovative quality, that's how the copyright can be. And there are few points in the copyright. One is the statutory right. Statutory right is nothing but by virtue of registration under a statute, Copyright Act 1957, it is recognizes the existence of such a right, and it authorizes the owner of the copyright to do what and what not. So this is a statutory right by virtue of registration. There is something like negative right, because copying itself is a negative right, everyone knows, in the sense that it stops others from exploiting the work of the author for their own benefit without the consent or license. So that's which gives a negative right. And as we discussed about the multiple rights, there is something like literary, dramatic and musical works, original artistic works, cinematograph film, and sound recordings. And it is nothing but a bundle of rights in the copyright. And there are two other things. One is the economic right. Of course, economic rights I need not to say, because the ones we get the registration by in terms of royalty, one of the best example I quoted is the J.K. Rowling, and our income is, the richest woman in the world. So that's how the economical benefit you get by virtue of registration. And next is the moral rights. Rights of publication, rights to claim authorship, the right of integrity. Take the example of Gitanjali. Everyone knows that it is written by Rabindranath Tagore. Even after it has come into the public domain after 60 years of its expiry from the date of the death of the author. And if somebody is still copying something from the Gitanjali, it gives you your moral rights to say that you are copying, even though there is no copyright after 60 years. So this gives you a moral right, because still your rights are recognized by virtue of its, the popularity of that copyright involved in that particular book, Gitanjali. So these are the kind of rights which we can discuss in the copyrights. And next domain of the subject is a very interesting subject, is the designs. Because normally design is something which is applied to an article and is not the article itself. The reason, because, for example, why I quote a best example, suppose a building is there. A building itself is a design, but the building of such cannot be registered. But the small module of the building, you prepared and put it in the exhibition in the glass wall to show that this is the kind of building we are going to make it. That module can be registered as a design, but not the design of the particular product itself. And important characters and features of the design are shape, configuration, pattern, and ornament. A design applied to shoes, textiles, and the three-dimensional pictures of the design which is being registered. This is only external features of the product. Internal mechanism and functionality can be registered as a patent, but only external, the look of the external product can be registered as a design. It is governed by the Design Act 2001. Now, what are the designs in general? Because some of the important aspects we'll be covering with the demonstration with the diagrams over here. Now, all of you see this Barbie doll. The child doesn't know anything, but you give several dolls, but give a Barbie doll. And the child gets impressed out of it, because the way it looks like, the doll looks like, the Barbie is very famous. So likewise, because especially when you look into the comparison of the vehicles. Now, if you look into the Alto and Santro at that point of time, I just demonstrated for your understanding, engine performance of the Santro was far better than the Alto, of the same nature of the vehicle, of same parameters and characteristics. But still people preferred more to the Alto, because this external look of the Alto was better than the Santro. So why I'm emphasizing on this point is because you got a wonderful trademark, you have got a wonderful product, and you got a all color appearance of like a copyright and the ambience of the external features of the body, but the design is not good. Still the product doesn't click, because consumers are influenced by the appearance of the article in their choice. It is the visual appearance of the product which makes a more difference. So now, because I'll show some of the demonstration, I think the slide is there next, where I'll show how water is costing more just because of the design. And design of the goods increases the profits by attracting customers, undoubtedly, because all the concept of the intellectual property rights is to make the business and profits out of it. And already we discussed about which is applied to an article and not the article itself. And the features, of course, we discussed about the shape, configuration, pattern, and ornament. Yes. Now, kindly look into this, the importance of the design in the water bottles. Except Avian, I'm sure all the other bottles have got the same water, maybe picked up from one or other river with a different this thing. But ultimately, is the water you drink out of these all bottles are same. But why there is a difference of the pricing of these bottles? Aquafina maybe 16 or 20 rupees. Distillery of the similar nature, Kinley and other Vedanta, I think, and it is also same. But when you want to purchase the Qua bottle, which I shown the left side, left corner, that is costing 60 rupees when I seen, because one of the airport when I just got impressed by looking that bottle shape. But the problem here is because all the bottles have got the same quantity of water, quality of water, if not with little bit variance. But the price variance, when you compare with the purchasing, seeing the external beauty of this water bottle, Koi is costlier. I think it was 60 rupees. So that's how, because it is an indication to the manufacturers and any entrepreneur who have got a wonderful invention, wonderful name, wonderful copyright, artistic features. But if you don't give a proper design, I already quoted about the marriage example, nothing better than that. So this how people get impressed with the external beauty is also one of the intellectual property rights. You can get registration of the designs under the Design Act 2001, and that's how the design is working out. Now, most important subject, one another important subject is a geographical indication. And especially I am being from Hyderabad, and we are so famous because people come to Hyderabad just to say that they want to eat Hyderabad biryani. Whenever I visit Delhi or other parts of India, people say because bring either Karachi biscuits or Hyderabad biryani. So these are the type of, the geographical indication. The products are identified that particular area. Why the Scotch of Scotland? I quoted one other example, Scotch of Scotland. Why it is so famous? Scotland whiskey, Scotch. Why it is called Scotch? The water flowing on the terrain of the Scotland hills, on that earth, adding to that water, to the mineral content of that earth, the water added to that alcohol gives a separate taste than any other water. You get the alcohol, which is, malt alcohol, which is put up in the wooden cask in the Scotland. Get that alcohol to India, add the Indian water. You get the different taste. So that's how these products are identified with, like take the basmati rice. You can grow the basmati rice in Hyderabad also, but you don't get that aroma and taste of the rice which you produce at the northern Himalayan belt of India and the Pakistan. So likewise, the Darjeeling tea. Darjeeling tea leaves are available in the even Ooty also, but the taste of the Darjeeling tea leaves and this leaves are different. Kolhapuri chappals you can manufacture in Hyderabad, but the chappals are identified as a Kolhapuri chappal because in the Maharashtra, that particular place, the chappals are being very famous. Like Mysore silk, Pochampalli sarees, Banaras silk, Kashmiri silk, so many are there, very famous. So these all the right attached to the products of the particular area. This gives the right to producers only from those regions to name the produce by these names. So likewise, it is identified by the particular locality. Now, likewise, I told you about the basmati rice, champagne, and the Pochampalli sarees. So these are the very famous because the Geographical Indication Act, separate act is there, 1999 Act, under which the Tirupati Laddu is also geographical indication is granted. I think that is in the litigation. I'm right now. I'm not sure what is the status of that. But these are Tirupati Laddu. The laddu you can manufacture every, but the aroma and taste you get of the Tirupati Laddu, which is being produced at the Tirupati Lord Balaji Prasadam. So these are all famous geographical indications. The basic difference between the trademarks and geographical indications is that a geographical indication can be registered on the name of the associations formed to protect that particular product, which cannot be assigned. Whereas the trademarks and other marks can be registered on the individuals and other entities, which can be assigned and transferred when they don't want it. And these are some other, geographical indications which I quoted because one of the toys of the, in the state of Telangana, Kundapalli toys is called Alpensus mangoes, Kolhapuri chappal, Darjeeling tea. So this is how the law is being changed by virtue of, GATT transformed because the TRIPS agreement, India being the signatory. So these are some of the important intellectual property rights and geographical indications. Now, I think we are slowly moving out of the subject now because it is also related to this. Evolution of the jurisprudence has become very important now. The reason because the person, when somebody got the registration of the intellectual property rights and when somebody started violating, now what is the remedy available to the person? The most of the people are not quite aware with the procedures involved in the courts Now, normally when somebody goes to the court, they want simply they know that they want an injunction. Injunction is restraining or stopping the person who is violating the rights of the inventor or who is the rightful or statutory rights conferred on the by virtue of registration. That is what we call normally injunction. There are something like interim injunction and permanent injunction. Normally, when the suit is being filed in the court, it takes almost 1 year to 2 years to get an injunction. That is called the end of the case of that complete trial, framing of issues, and all the completion of pleadings. What you get in the form of decree from the court is called as a permanent injunction, the restraining the person from using some such things, whatever the prayer is being sought in the suit. Now, but it takes years together. Now, in the meantime, the person start using. If the prima facie court is satisfied on the documents available at the initial stage of the litigation, the court may pass an interim order restraining the other person from stopping using the product by way of calling as a temporary injunction. But before that, when somebody files a case, normally court says that let other person also appear and take the pleadings, then the order can be passed. But in the extreme situations, when there is an imminent threat and danger, irreparable loss to be happened, when you are able to demonstrate the prima facie case, the court can pass the ex parte order against the person who has not appeared till the time. So these are the basic orders to be understood in the general domain of the practice of the any counsels in the Indian courts are all through the world. But there are something like the other aspects of the injunctions which we are discussing here is like Mareva injunction, Anton Pillar order, John Doe order, and quiet amendment action. And these are the evolution of the jurisprudence in the Indian context, because in normal practice, when you are dealing with the real estate property or any other property, you never come across this kind of orders. What is that Mareva injunction? This is something like the restraining the defendant from removing the assets from the jurisdiction or dealing with or parting with the assets in such a way as to render the execution of the decree. Now, when somebody is approaching the court, suppose if the defendant removes the assets from the jurisdiction so that at the end of the stage, execution of the decree becomes impractical. Under those circumstances, the court can grant an order saying that the defendant from not to remove the assets from the jurisdiction. It's something like in what you call in the Indian normal context we call is the attachment before judgment sort of thing. So it restrains the person from disposing of his assets until the determination of the case between the suing the party. Now there is something like Anton Pillar order. Now Anton Pillar order is the order which is also called as in the Indian context is called also in the Anton Pillar order, the court grants in such an injunction that it allows the applicants to search the premises of the respondents, because without the grant of the court order, you can't go and you're not able to get any evidence from the defendant saying that he is committing such a crime. But practically, if you go and visit that place, the crime is visible and apparently available for the persons to identify that. Under those circumstances, a court can grant an order where it allows the applicants to search the premises of the respondent and seize the relevant evidence. The purpose of search is to preserve the evidence. For example, X company goes to the court and say that my software is being pirated and my software is being used by the Y company, for which, for example, Microsoft has got the software. Most of the companies use the pirated software. Now, if the Microsoft files a case because he is the owner of the software without his permission, so and so person is using in his establishment, there are 100 to 200 computers. Under those circumstances, you can't go and verify because no one will permit you to enter into that. The court can pass an Anton Pillar order saying that then and there the applicant is permitted to visit the premises, if possible with the police protection, to seize all those computers to gather the evidence so that later part evidence cannot be disturbed, so that to decide the list and to decide the case in the litigation at the time of trial. And next, another important aspect is the John Doe order. John Doe, precisely, it is also called Ashok Kumar order in Indian context. Now, it is one of the most important aspect of the order which you can invite in the intellectual property rights, more specifically in the copyright. For example, take the Bahubali movie. And movie gets released on the Friday, and Saturday morning you find the all through the electronic shops or the shops where they tell the CDs, and that CD could be more having the better clarity than the original CDs also. Now, if that is CD is available in the market, then what will happen to the person who has invested crores of rupees for the producing the movie, and people started violating, no one will go to the theaters. Now, under those circumstances, normally what happens if you approach the court for the seeking a remedy against the defendant, you should know the person who is violating, what is his address, and is it possible for a person there are lakhs of shops in the India are violating that order? Is it practically possible to the person to file a cases against the lakhs of the people as the defendants? Impossible. Under those circumstances, you can unknown defendant, you can file the case before the court, whose name can be called as a John Doe. And if the court is satisfied prima facie case and balance of convenience, the court passes an order to take action against all those persons who are violating the order. Is a John Doe order. It is an order in rem rather than order in personam, we can call it as. So these are the kind of evolution of the jurisprudence could happen only in the intellectual property right matters. And in normal practices, these are the kind of things never happen. And one another most important jurisprudence aspect of the evolution of the jurisprudence is the quiet action. It mostly happens in the patent infringement suits. Now, somebody is violating the rights, you can go to the court and say that he is violating my rights. This is the example, this is the proof, this is the evidence. But somebody is going to violate, and in future he is going to, in anticipation, can you go to the court is the aspect. Now, this is the quiet action is one such thing, because if you are able to demonstrate before the court, say that the defendant is going to violate my rights, I am having the patent rights or infringe IPR rights over the particular concept of the subject, and this person has put up something material on the website, for example, to say that he is going to launch this product. That product could be similar to my product. There is no other way you can use any other product without copying my product. If you are able to demonstrate without cause of action, because it is one of the wonderful concept of Indian legal jurisprudence, the reason, because if somebody started or invested something and started the product, if the court gives the order, it will be lost to the defendant. But if you are able to demonstrate that defendant is going to violate your rights, if the court is satisfied in the interest of the plaintiff and the defendant, this kind of orders can be granted under the quiet action. And especially this could be the slides, which is completely different from all other aspects of the other speakers who will be talking on this. And really, it is a very interesting kind of, the evolution of the jurisprudence in Indian courts. And most importantly, these all happens in the intellectual property rights India. I think I got the 15 minutes more time. And I'm sure I don't know because any question answer session is there. But now, sir.
Sir, there are a couple of questions, so maybe another 5 minutes and then we can take the
in 5 minutes. I'll just complete because it's self-explanatory and nothing big to be spoken on this. Because
sure.
Viewers are more intelligent than me because they know more better than me. Now these are because to establish and demonstrate the emerging trends in IPR is that's because the government has come up with the Skill India, Digital India, new IPR policy is being constituted. And because now that today I see Hyderabad is competing with Bangalore and Pune is also competing with all other cities with regard to the startups and incubators to encourage the persons who have coming with the brilliant ideas and to promote these ideas, these startups and incubators have come up. IPR policies for the companies, IPR departments, R&D in universities and companies. In the initial speech, I think Mr. G.S. Prasad and Mr. Rajiv Ankasap and Arun Agarwal ji has rightly said that because R&D in universities and companies. Now, I was wondering because in the recent COVID pandemic, IIT Bombay and many other IITs have come out with their own inventions. And these are the places where if you keep encouraging the people of their inventions, why at all you should work with someone? You create an employment, you invent something, many people can work under you. And these are the great evolution in Indian history, encouraging the IPR policy, and a salute to the government because coming with a new IPR policy also being framed now. And see, nowadays, the companies used to have labor department and HR department. There are IPR departments are being constituted. You can understand the importance of this kind of subject, and the IPR policies for the companies also the order of the day. And ladies and gentlemen, I think I exactly completed you got almost 15 minutes time for any question and answers. And I think if sir, if the time is there, I can take for some more time. But if the question answers is there, I can stop it here.
So there are a couple of questions, and I would actually take on their behalf because they cannot directly ask because they are on YouTube. So I'll take one by one, and then probably you can answer to this. So let me first thank you for such an elaborated talk. It was wonderful to listen to you. And a few questions now they are coming.
Sir.
There are a couple of people who asked the same question. The question is that how to file IPR? Is there any specific simplified set of steps available?
No, when you said that IPR, sir, IPR subject domain where is a trademark, patent, or copyright. Now, as I told, the procedure is almost all same in every aspect: filing of an application, objection from the respective department, and compliance of those objections. You have to reply to those. And if the controller of trademark, if it is a trademark, it is a trademark registrar, and if it is a patent, it is a controller. If they satisfy with that, it will go for especially in the patent, there is something like pre-grant opposition and post-grant opposition. But unlike in the trademarks, it is the journal publication when it is being done, opposition could be there. And once the person can get through all these things, then the registration could happen. But of such IPR registration is not a general thing. But IPR subject matter design registration is governed by specific principles, patent, copyright, trademark. All are governed by different domains of the registration mechanisms.
Okay. So there is another question from TVS Aditya Sandeep, and he asks, sir, would that person be able to patent his traditional medicine against COVID if Ayush and ICMR prove its significance in future?
Very good question, sir. I really anticipated that this question would come. Today I was shocked because today only the news there was because yesterday Anandaya is a person, if you can Google out, I don't know whether it is available in the Google also, a person from some Krishnapatnam in the Andhra Pradesh. Everybody is happy. The person was to die. Doctor declared he will die. This guy took a medicine and he was all right. Maybe faith or maybe whatever. But today the police is not able to control the crowd before his house. And he has been arrested for the reason for the safety. And Ayush is exploring the possibility of giving the permission to him. I don't know whether today evening or tomorrow the results will come. Probably there could be a lot of hiccups of the bureaucracy and whatnot. But the problem is, these I told very categorically, traditional knowledge cannot be registered. The reason, because this is available in the public domain for a long time. That is one issue. Second issue, putting my legal knowledge to this, you document this product and go for a copyright registration. You will get a more protected for the 60 years than having the patent registration for 20 years. And precisely, I'm sure the Ayush will come out with some positive thing because there are no side effects for this. Even the person whether likes or doesn't like, if there are no side effects, the medicine should be permitted is my personal opinion. But of such traditional knowledge cannot be registered under the Patent Acts.
Thank you, sir. So there's a next question is actually regarding to Mr. Anandaya only. So it says, sir, in Anandaya case, what is the requirement for getting a patent for this herbal condition, which I think you have already actually said it in your earlier answer. There is a question from Mr. Sachin. Can we define property in any other words?
Yes.
There is another, actually he asked 3 questions. I'll just read 3, all of them.
Yeah,
how to say a competition keeps business on the edge and to keep improving. And the third question is, Mahindra is a good trademark and multiple company. So what is a response like?
Yes, sir, Mahindra is the name of a person like Dr. Reddy's. Now, interestingly, the Mahindra has got also several litigation on this point because the people Mahindra is being considered as because they are having the wide network of the business, transborder reputation, and their well reputation in the market. Mahindra is considered one of the well-known trademark, like Dr. Reddy's. And once it is declared as the particular brand name as a well-known trademark, no other person or entity is permitted to use the name of Mahindra. Even those persons have, like Godrej is there, Tata, all these are the names only, Dr. Reddy's. By virtue of their, it has declared as the well-known trademark, no other person is permitted to use those names for any other product in all the classification of the goods. Sir.
Thank you, sir. So there is another question, probably you have already answered it, that like patent once published, how long it is valid? Is it compulsory to get the grants for published patents? Dr. Parvati asked, and probably you already answered it into your first answer. There is another remark by Mr. Alok Hirani. He says that there is no mention of how the traditional knowledge systems were stolen in your talk.
Yes, I'll had cut at least my personal experience. There is something like Kriya Yoga by one of the yogi in the Kolkata. I am not putting the name of any person on that. One of the disciples joined with him. And as I said, we Indians are very poor in documentation. And she learned everything from this person, and she left India, and she has documented in a wonderful book in the Kriya Yoga. And she got a royalty on some crores of rupees, and this yogi has got nothing from this. Now, of course, we filed a case that is a different story. But the problem is, once you have knowledge on this, as I said rightly, because you know many things, but you don't know how to demonstrate or exhibit, then you know nothing. Because you should be having the equally good skills to demonstrate or put the documentation of all your inventions and knowledge. Then either it can be registered in any one form, either it could be in the form of a copyright or the book, and some sort of invention which the product will come out. And there are methods and mechanisms people are not aware of. And thanks to the organizers conducting the workshops like this, because this kind of the seminars will, helps in encouraging the people to understand the subject and brings the awareness. And these are very, very important, like workshops and seminars like this, sir.
Thank you, sir. There is a question from
Rajesh.
Yeah.
Can I just add a few lines?
Yeah, please.
Yeah. See, I think Reddy sir has touched on about that somebody patented the...
Professor Prasad, can you... yeah. Thank you very much. Switch off your camera. Yeah.
Somebody patenting the Haldi patent, right?
Correct, sir.
So actually CSIR fought it in the US courts.
You're right, sir.
And when Dr. Mashelkar was our DG, instantly I was in CSIR for quite some time before moving to University of Hyderabad.
Sir.
So in fact, after that, CSIR has created a separate traditional knowledge digital library.
Exactly.
Also maybe knowing that where they have documented the entire traditional knowledge in the form of that library. So now probably whatever this Anandaya using, that also may be documented there in that library. This is just
you are perfectly correct, sir, because that is TKDL, Traditional Knowledge Digital Library.
Digital library. And
there is a committee is being constituted by the government, and so important, sir, government is taking the initiation because AYUSH department is the new complete separate department now.
Yeah.
Now, many things are like Bhattini Gaud's fish medicine, which we know, but there are many medicines. If you go to villages, sir, I think tribals, many of those people never use any allopathic medicines. And even today, because of the COVID, because we know that many people are using the traditional methods of treatment rather than going for the allopathy. So these are all to be documented so that we can protect our traditional knowledge. That is the only way to do that.
Yes, sir. Very informative talk, sir. I just also wanted to add one more line. You were also referring about the patenting the microorganisms.
Correct.
Yeah, when the first International Depository Authority was established in the Institute of Microbial Technology, Chandigarh, in 2003,
sir,
I was the person who was looking after that depository from 2003 to 2018, 15 years.
Sure. Great, sir.
Thank you.
So, right, sir. Raju, sir.
Yes, I think he lost the connection.
No, I think he stopped it.
Okay. So there are a couple of more questions. If you have a time, I can quickly ask.
Because unless it's not disturbing your next program.
Maybe one question, like if someone steals my idea and using the same idea to different products, they file the patent before me or in parallel to me?
Yeah, very good.
Am I in the loss or still I can fight for that and file the patent in my name? That asked by Dipaksha Gupta.
In general context, I'll tell you, sir, it's a very interesting question because again, I come to the point of documentation. As a counsel, I see, take the example of somebody is going and telling the story to the producer and director to release the movie. And suppose that story is being heard by them. This guy goes out, he says that, no, we don't want to go with you. Then after 1 year, they have got the same movie, what the film he has given, a story has given to the producer and film. Unless there is a documentation, because somebody you are disclosing, suppose you are working for a particular institution, you are working in R&D, unless there is a documentation to say that your particular invention during the employment of your organization, whether that invention goes to you, or whether this invention goes to the institution, or whether this invention goes to both the parties. So that kind of agreement or documentation is not there. Again, it's the scope of litigation. So similarly, when you disclose your patent to someone, you should have a non-disclosure agreement. I don't think anybody would be dare enough to do that, because the person who is going to disclose his invention, he don't have money. The person who is going to listen to that invention, he got the sufficient money. So at least some sort of documentation, I put it, address a mail saying that tomorrow I'm coming to you to disclose so and so something. That will become a piece of evidence to you to later stage to show that because he has filed an application knowing from me. So this kind of documentation is very, very important, sir, because many litigations are there in this aspect. So this is like a balancing approach that people should, because people should be clever enough to do sort of create some sort of documentation.
Thank you, sir. So there are very quick two questions actually. First is from Laksha Singh. He is asking, can IPR be imposed on religious things in the name of the religion? For example, IPR case of Tirupati Laddu.
No, when you specifically refer about the Tirupati Laddu, sir, it's not the matter of Tirupati Laddu. If I put it in different way, because in Halim, Hyderabad is only Ramjan period it is available. It doesn't mean that because Muslims only eat the Halim, because most of the people are more than the Muslims, Hindus eat that. No, it's not the Tirupati Laddu, is the kind of taste and aroma which is being for that particular area which is being manufactured. I'm telling you, many people were praised. And those Tirupati Laddu earlier point of time used to preserve for the almost months and nothing, it never gets damaged. So kind of quality and the taste it gets, it is not for the any religion color, but it is for the that particular product. But of such, sir, as you rightly asked, because the names of the gods are putting the like Sri Rama so and so shop or some any other any religion name, that is not acceptable unless that is clubbed with some other names. Not for Rama. If the Rama is part of the name of the any brand name, that Rama can be disclaimed, but rest all can be given a rights to use that. But you can't have any monopoly rights on the Krishna or Rama or any other religion name. So you can't have any religious nomenclature in the IPR.
Thank you, sir. So the last question from our side is from TVS Aditya Sandeep. And the question is that if the objection against the proposed patent gets dismissed, will those who are objectioning parties will be penalized through money or some other form?
I don't think, because there is nothing like the penalizing the people. You are fighting for your rights and you make an application just because your objection is but it is a frivolous patent or something like that. I don't know, because you are paying the money to while filing of an application. There is a statutory amounts paid for every stage of the patent registration. There is nothing like penalization, sir.
Okay. So there are several other questions. Probably we can take them offline and we can get a response from your side.
Always, sir. Most welcome. Any of the viewers, anytime. I'm sorry because I'm just out from COVID. Yesterday only I got negative after 20 days of quarantine, and I was a bit. There is no vibration, there is no modulation in my voice. Also, I'm sorry if somebody is having inconvenience just because of my modulation in the voice. Thank you so much, all the viewers, for.
We are really thankful to you for. This like accepting our invitation on the behalf of University of Hyderabad and the whole IIC committee. And Professor G.S. Prasad, would you like to?
No, I just wanted to thank Reddy sir for this wonderful session.
Thank you so much, sir. Thank you so much.
Thank you very much, sir. So I think PVC sir also has joined again. Rajiv ji.
Professor Agrawal,
yes. Let us.
No, I would like to thank Dr. Venkat Reddy sir for kindly accepting our invitation. I also really enjoyed listening attentively for last 2 hours.
Thank you so much.
I think it was a wonderful information which you have given, which covered a lot of breadth. And like you rightly said, you have not got into the depth of the matters. But I think you had given a full landscape of things which are important in this area. And again, on behalf of the university, I extend a big thank you to you. And I hope we will continue our interaction after the workshop also. I know you are helping us conduct our postgraduate diploma.
Yes.
With the help of Mr. Rajiv Ankar, but we will definitely like you to visit our campus when things become normal, and let us hope we can take our relationship further. And
thank you so much.
Thank you, and thank you once again. Thank you.
Thank you so
Thank you,
much.
sir. Thank you so much. So with that, we would end today's session before the lunch, and post-lunch we would be meeting again for the next talk by Dr. Aarti Tyagi at 2 o'clock.
Thank you
So let us break for the lunch. Thank you, sir. Thank you so much.